Part of this hour that in this module, I want to cover three topics. I want to talk about the levels of scrutiny. I want to talk about substantive due process. And finally, third major topic is equal protection. This, of course, is the provision in the 14th Amendment that no state shall deny any person equal protection of the laws. Whenever the government draws a distinction among people, there's the basis for an equal protection challenge. Major subpoint A, an approach to equal protection. All equal protection questions, all equal protection cases can be broken down into three steps. Point one, what is the classification? How is the government drawing a distinction among people? Point two, what is the level of scrutiny? Over the course of the next half hour, I will tell you every area where the Supreme Court has approved an immediate or strict scrutiny under equal protection. In point three, does the government's action meet the level of scrutiny? The level of scrutiny is the rule that's applied to the law, to the government's action in the question. Every equal protection case is always litigating about one or more of these three questions. Major subpoint B, constitutional provisions concerning equal protection. Point one, the Equal Protection Clause of the 14th Amendment applies only to state and local governments. Very important reminder, the 14th Amendment itself never applies to the federal government. Point two, equal protection is applied to the federal government through the Due Process Clause of the Fifth Amendment. There's no provision in the Constitution that says the federal government cannot deny equal protection. But the Supreme Court has said that the Due Process Clause in the Fifth Amendment, which applies to the federal government, includes a requirement for equal protection. The law is the same with regard to equal protection, whatever the level of government. Just always remember, equal protection is applied to state and local governments through the 14th Amendment. Equal protection is applied to the federal government through the Fifth Amendment. Major subpoint C with regard to equal protection, race and national origin classifications. Point one, strict scrutiny is used. Whenever the government discriminates against people on account of their race or their national origin, the country that they or their ancestors came from, strict scrutiny is the test. Point two, how is the existence of a race or national origin classification proven? How is the existence of a race or national origin classification proven? I just said, if it's a race or national origin classification, strict scrutiny. But how is it determined whether this exists? There are two alternative ways. A, the classification exists on the face of the law. That is, the law, in its very terms, draws a distinction among people based on race or national origin. Example, in the 19th century, West Virginia had a law that said that only white men could serve on juries. The racial classification, and for that matter, the gender classification, was evident right on the face of the law. Another example, until 1954, in Brown versus Board of Education, Southern states had laws that said that black children and white children could not attend the same public schools. The racial classifications were evident on the face of those statutes. Sub B. Alternatively, if a law is facially race neutral, proving the existence of a racial classification requires demonstrating both discriminatory impact and discriminatory intent. Alternatively, the law is facially race neutral. Proving a racial classification requires demonstrating both discriminatory impact and discriminatory intent. The most important case here was Washington versus Davis in 1976. Washington, D.C. had an ordinance that said in order for a person to be a police officer, the individual had to pass a test. Statistics showed that African Americans failed that test significantly more often than whites. A challenge was brought under equal protection. But the Supreme Court said only rational basis review. The court said proving a racially discriminatory impact is not enough to prove that there's a racial classification. It's not enough to get higher than rational basis review. The court said that the plaintiffs would have to also prove that the intent behind the requirement was to disadvantage blacks in order to be treated as a racial classification. When the law is facially neutral, such a requirement that people have to pass a test in order to be police officers, to treat it as a racial classification, to get more than rational basis review, requires showing both that there's a discriminatory impact of the law and that there's a discriminatory intent behind the law. An important application of this is that the discriminatory use of peremptory challenges based on race violates equal protection. The discriminatory use of peremptory challenges based on race violates equal protection. Laws that provide for peremptory challenges, strikes of prospective jurors, are facially race neutral. But when people are excused from jury service on account of their race, there's both the discriminatory impact and a discriminatory intent. The Supreme Court has said it doesn't matter if it's a criminal or civil case. It doesn't matter if it's the prosecutor, the plaintiff, or the defendant. The discriminatory use of peremptory challenges based on race violates equal protection because the court sees there as being both discriminatory impact and discriminatory intent. Point 3. How should racial classifications benefiting minorities be treated? In discussing how racial classifications benefit minorities be treated, I'll begin in sub A. Strict scrutiny is used. It doesn't matter whether the racial classification is invidious, disadvantaging racial minorities, or benign, benefiting racial minorities. All racial classifications must meet strict scrutiny. Sub B. Numerical set-asides require clear proof of past discrimination. Numerical set-asides require clear proof of past discrimination. Over the last quarter century, the Supreme Court has shown that it's very hostile to anything that looks like a quota or a set-aside. The Supreme Court has said that a set-aside will be allowed only if it's a remedy for clearly proven past discrimination. There's only one case upholding a set-aside that still seems to be good law. The case was United States versus Paradise about 30 years ago. A federal district court in Alabama found that the Alabama State Police had engaged in unconstitutional race discrimination in hiring and promotion. So the federal district court, as a remedy, said, every time a white individual is hired or promoted, an African-American individual is hired or promoted, until the effects of the discrimination were alleviated. This was, in essence, a 50% set-aside. But the Supreme Court upheld it as constitutional. The Supreme Court said it was permissible because it was a remedy for clearly proven past discrimination. Sub C. Educational institutions may use race as one factor among many to benefit minorities and enhance diversity. Educational institutions may use race as one factor among many so as to benefit minorities and enhance diversity. This was the holding in Grutter versus Bollinger in June of 2003. There, the Supreme Court said that colleges and universities have a compelling interest in having a diverse student body. Colleges and universities may use race as one factor among many in their admission decisions to benefit minorities and enhance diversity. But colleges and universities cannot add points to applicants' admission scores solely on the basis of race. Colleges and universities cannot add points to applicants' admission scores solely on the basis of race. This was a companion case, Gratz versus Bollinger, also decided in 2003. The University of Michigan Undergraduate Admissions Office assigned points to various features in the applicant's profile. Additional points were added to those for minority races. The Supreme Court declared this unconstitutional. It said universities cannot add points to an applicant's admission score solely on the basis of race. And finally, sub D, the use of race in assigning students to elementary and high school students must meet strict scrutiny. The use of race in assigning students to elementary and high schools must meet strict scrutiny. This was the holding in 2007 in parents involved in community schools for Seattle School District Number 1. For high schools in Seattle, a number of factors were considered in assigning students. The most important factor was siblings. If somebody had a sibling at a school, they would get priority in admission. But another very important factor was race. If schools were not racially diverse, students would be assigned to create the diversity. There was a companion case to the Supreme Court. It came from Louisville, and it used race as a factor in assigning students from K through 12. The Supreme Court declared this unconstitutional and held that elementary and high school systems cannot use race in assigning students unless they can meet strict scrutiny. I'm now at major subpoint D with regard to equal protection, and that's gender discrimination. Point 1, intermediate scrutiny is used when the government discriminates against people on the basis of sex. It's well established that intermediate scrutiny is the test. Interestingly, though, the court here has added another requirement on to intermediate scrutiny. The court has also said that if the government is going to discriminate based on sex, there must be, quote, an exceedingly persuasive justification. The test is still intermediate scrutiny, but the court has also said if the government is going to discriminate on the basis of sex, there must be, quote, an exceedingly persuasive justification. Point 2, how is the existence of a gender classification proven? By the way, do you know how to tell the difference between a boy chromosome and a girl chromosome? You pull down its genes. There's 2 ways of proving the existence of a gender classification, and they're identical to the ways of proving a racial classification that I discussed just a few moments ago. Sub A, the classification exists on the face of the law. That is, the law in its very terms draws a distinction among people based on sex. Example, in Craig versus Boren, the Supreme Court considered an Oklahoma law that said that women could buy low-alcohol beer at age 18, but men could not buy low-alcohol beer until age 21. The gender classification was on the face of the law. The court used intermediate scrutiny and declared it unconstitutional. Another example, United States versus Virginia. This case involved the Virginia Military Institute. Is a state university, but by state law, entirely male. The Supreme Court declared this unconstitutional. The court said there was no exceedingly persuasive justification for excluding women. The court applied intermediate scrutiny and declared the law unconstitutional. Sub B. Alternatively, the law is facially neutral with regard to gender. Proving a gender classification requires demonstrating both discriminatory impact and discriminatory intent. Just as for race, alternatively, the law is facially gender neutral. Proving a gender classification requires demonstrating both discriminatory impact and discriminatory intent. Imagine that a city has an ordinance that says that in order for a person to be a police officer or a firefighter, the individual has to be at least 5'10" and weigh 150 pounds. Statistics show that almost half of all men will meet that height and weight requirement, though obviously not including me, but only about 2% of women will meet the height and weight requirement. What level of scrutiny? Only rational basis review, unless the plaintiffs can prove that the purpose behind the requirement was to disadvantage women. Again, an important application here. The discriminatory use of peremptory challenges based on gender violates equal protection. Just as with race, the discriminatory use of peremptory challenges, excusing prospective jurors on the basis of gender, violates equal protection. Point 3. How should gender classifications benefiting women be treated? Intermediate scrutiny is the test. It doesn't matter whether the gender classification disadvantages or benefits women. Intermediate scrutiny is still the rule to apply. But it's also possible to discern a couple of more specific rules as to how the court treats gender classifications benefiting women. Sub A, gender classifications benefiting women based on role stereotypes are not allowed. Gender classifications benefiting women based on role stereotypes are not allowed. The Supreme Court has explained that many gender classifications that appear to benefit women in reality perpetuate destructive stereotypes. Example, Alabama had a law that said in case of a divorce, a woman could be awarded alimony, but a man never could be awarded alimony. The Supreme Court declared this unconstitutional because this is based on a stereotype that women are economically dependent on their husbands and men are always economically independent of their wives. There have been many cases before the Supreme Court about laws that say if a woman's husband dies, she automatically gets survivor benefits. But if a man's wife dies, he gets benefits only if he can prove that he was dependent on her income. Again, such laws are always unconstitutional because they're based on a stereotype of economically dependent women and economically independent men. Sub B, gender classifications benefiting women designed to remedy past discrimination or differences in opportunities will be allowed. Gender classifications benefiting women that are designed to remedy past discrimination or differences in opportunities will be allowed. As an example, the Social Security Administration used a different formula to calculate benefits for women than it used for men. The formula benefited women. The Supreme Court upheld it as constitutional. The court said there's a long history of wage discrimination against women in the American economy. The court said that the difference in the formula was permissible as a way to compensate for this. Or another example you might remember, the Navy had a regulation that said if a man was not promoted within 6 years, he had to leave the Navy. But a woman could go about 10 years without a promotion before she had to leave the Navy. The Supreme Court upheld it as constitutional. The court said because men could serve in combat, whereas women could not serve in combat, men had more opportunities for the kinds of behavior that would earn promotions. The court said the difference in the formula is meant to compensate for differences in opportunities. Major subpoint E, alienage classifications. Alienage classifications refer to laws that discriminate against non-United States citizens. With regard to alienage classifications, discrimination against non-citizens, several things you need to know. Point 1, generally strict scrutiny is used. Example, state had a law that said only United States citizens could receive welfare benefits from the state. The Supreme Court used strict scrutiny and declared the law unconstitutional. Example, state had a law that said only United States citizens could have civil service jobs in the state. The Supreme Court used strict scrutiny and declared the law unconstitutional. Example, the state had a law that said only United States citizens could be admitted to the bar to practice law in the state. The court used strict scrutiny and declared the law unconstitutional. So the general rule is strict scrutiny when the government discriminates against non-citizens. What makes this area of law difficult is that there are several exceptions where the court has approved less than strict scrutiny for discrimination against non-citizens. Point 2. Only a rational basis test is used for alienage classifications related to self-government and the democratic process. Only a rational basis test is used for alienage classifications related to self-government and the democratic process. Here's the bottom line. The government can discriminate against non-citizens with regard to voting, serving on a jury, being a police officer, a teacher, or a probation officer. The government can discriminate against non-citizens with regard to voting, serving on a jury, being a police officer, a teacher, or a probation officer. To explain, the Supreme Court long has said that the government can reserve some privileges just for citizens, those that relate to self-government in the democratic process. And so it's long been the law that the government can deny non-citizens of the right to vote or the ability to serve on a jury. Then there was a case before the Supreme Court that involved a state law that said, in order to be a police officer in the state, a person had to be a United States citizen. The Supreme Court said, police officers are integral to self-government. They enforce the laws that are the product of the democratic process. The court said, only rational basis review, and upheld the law. Next, before the Supreme Court, was a state law that said, in order to be a teacher in the state, a person had to be a United States citizen. A high school French teacher who was a citizen of France and not the United States brought a challenge to that. She lost. The Supreme Court said, teachers are integral to self-government because they're responsible for inculcating democratic values in our youth. The court used only rational basis review and upheld the law. Then there was before the court a case that involved a law that said, in order to be a probation officer in the state, a person had to be a United States citizen. The Supreme Court said, probation officers are just like police officers. There's no reason to treat it any differently. They're enforcing the law. Rational basis review, the government won. The final case so far to come before the Supreme Court involved a state law that said, in order to be a notary public in the state, a person had to be a United States citizen. The Supreme Court declared that law unconstitutional. The court said, notary publics don't have anything to do with self-government in the democratic process. They just put those anachronistic seals on things. So that law was found to violate equal protection. Point 3, only a rational basis test is used for congressional discrimination against aliens. Only a rational basis test is used for congressional discrimination against aliens. If it's Congress that's discriminating against aliens, rational basis review. Why? The Supreme Court has said that Congress has plenary power to regulate immigration. So when Congress discriminates against aliens, it's thought to be an exercise of that power. In point 4, it appears that intermediate scrutiny is used for discrimination against undocumented alien children. It appears that intermediate scrutiny is used for discrimination against undocumented alien children. There's only been one Supreme Court case about undocumented aliens and equal protection. The case was Plyler versus Doe in 1982. Texas adopted a law that said that children of citizens and children of documented aliens would get a free public education, but children of undocumented aliens have to pay for their public education. The Supreme Court declared this Texas law unconstitutional. Interestingly, the court didn't expressly identify the level of scrutiny that it was using. But I think the court was clear it was using more than rational basis review, but less than strict scrutiny. It appears that the court used intermediate scrutiny in striking down this Texas law. Major subpoint F, discrimination against non-marital children, so-called legitimacy classifications. Point 1, intermediate scrutiny is used. Intermediate scrutiny is the test if the government discriminates against children whose parents were not married. Point 2, laws that provide a benefit to all marital children, but no non-marital children, are always unconstitutional. Laws that provide a benefit to all marital children, but no non-marital children, are always unconstitutional. Intermediate scrutiny is still the test, but such laws fail. Example, state adopted a law that said that only children of marital relationships could inherit from their fathers. All children of married parents could inherit from their fathers, no children of unmarried parents could inherit from their fathers. The court used intermediate scrutiny and declared this unconstitutional. The harder cases, and the ones that are just treated case by case under equal protection, is where the law provides a benefit to some non-marital children that it denies to other non-marital children. Then it's just case by case under intermediate scrutiny. Example, state adopted a law that said a non-marital child could inherit from his or her father only if paternity was established during the father's lifetime. Some non-marital children could inherit, where paternity was so established. Other non-marital children could not inherit. The Supreme Court upheld that law and found that it met intermediate scrutiny. The court said that the government had an important interest in fraud, and requiring that paternity be established during the father's lifetime is substantially related to that goal. So I have now covered all of the areas where heightened scrutiny, strict scrutiny, or intermediate scrutiny is used. I looked at race, where it's strict scrutiny, gender, where it's intermediate scrutiny. I looked at alienage, where it's generally strict scrutiny. And I looked at legitimacy, where it's also intermediate scrutiny. I want to conclude here then with subpoint G by talking about the types of discrimination that get only rational basis review. So I complete equal protection, having looked at what gets heightened scrutiny, by examining the types of discrimination that get only rational basis review. There are a number of areas where the Supreme Court has used only rational basis review, so the law is clear. Point 1, age discrimination receives only rational basis review. Interestingly, there has never been a Supreme Court case in American history that has found government age discrimination to violate the Equal Protection Clause of the 14th Amendment. The cases before the Supreme Court have involved equal protection challenges to mandatory retirement laws. The Supreme Court has used rational basis review and has upheld those laws. Point 2, disability discrimination receives only rational basis review. Disability discrimination gets only rational basis review. You might remember the leading case here, City of Cleburne versus Cleburne Living Center. A town in Texas had a zoning ordinance that prevented a home for the mentally disabled from being located in its midst. The Supreme Court expressly held and later reaffirmed only rational basis review for discrimination against people with disabilities. Interestingly, though, the court struck down that Texas zoning ordinance, one of the few instances in which the government has lost under rational basis review under equal protection. Point 3, wealth discrimination receives only rational basis review. For over 45 years, the Supreme Court has been clear that poverty is not a suspect classification. Discrimination against the poor gets only rational basis review. Point 4, economic regulations receive only rational basis review. It doesn't matter whether an economic regulation is challenged under due process, which I talked about earlier, or under equal protection. It is still only rational basis review. I'll give you an example of a case that you might remember. It's a case called Dukes versus City of New Orleans. New Orleans adopted an ordinance that said, in order to be a pushcart vendor, like a hot dog salesperson in the French Quarter, a person had already worked there for at least 8 years. Those who had worked there less than 8 years said they were discriminated against, and they brought a challenge under equal protection. This is a case that, when it went to the Supreme Court, I always wished that Justice Frankfurter had written the opinion. The Supreme Court said, this is a government economic regulation, only rational basis review, and the government won. And finally, point 5, sexual orientation discrimination. What's interesting about sexual orientation discrimination is there have only been 3 Supreme Court cases about it. One expressly used rational basis review. The other 2 didn't say the level of scrutiny that was being applied. In Romer versus Evans in 1996, the Supreme Court declared unconstitutional a Colorado initiative They repealed all laws in the state protecting gays and lesbians from discrimination and prohibiting the enactment of new laws protecting gays and lesbians from discrimination. The court expressly said the Colorado initiative failed rational basis review. The court said it was based on animus against gays and lesbians, and that was not enough to constitute a legitimate government purpose. In United States versus Windsor in 2013, the court declared unconstitutional Section 3 of the Defense of Marriage Act as denying equal protection to gays and lesbians. Section 3 said that marriage for purpose of federal law and federal benefits had to be a man and a woman. The court found that this denied equal protection to same-sex couples who'd been married in the states that permitted it. But the court did not indicate the level of scrutiny that it was using. Most recently, in Oberfeld versus Hodges, in June of 2015, the court said that state laws that prohibit same-sex marriage deny equal protection as well as violate the right to marry. But once more, the court did not use the level of scrutiny. So the best, the most accurate that I can say to you is that the Supreme Court used rational basis review in Romer versus Evans, and the court didn't say the level of scrutiny that it was using for sexual orientation discrimination in the two most recent cases on the topic. That's all the court has said to this point with regard to the level of scrutiny to be used for sexual orientation discrimination. Since the only case said rational basis review, that's why I've listed it in this category. So what I've reviewed for you then with regard to equal protection is a framework for analysis, and I've identified the level of scrutiny to be used for each type of discrimination. That also then completes this module where I first reviewed the levels of scrutiny, and then I showed you how the levels of scrutiny apply with regard to individual rights in my discussion of substantive due process, and how the level of scrutiny applies with regard to equal protection.